My name is Howard Burns. I'm the editor of NJBIZ, and I want to welcome all of you to our monthly panel session. This month, we're concentrating on human resources. And I want to introduce you to our moderator this morning. He is Ed Dougherty, who has an extensive HR background with a focus on organizational alignment, process analysis, and compensation issues. In 2003, Ed formed Effective HR LLC, whose mission it is to improve the strategic perspective, operational effectiveness, and profitability of corporations, and to help nonprofit organizations achieve maximum operational effectiveness and focus. Ed spent more than 30 years at Prudential Financial in various employee benefit roles. He then spent several years in HR systems consulting roles before joining the Chubb Institute, where he had extensive oversight of HR and served on the management committee. Ladies and gentlemen, please give a warm welcome to Ed Dougherty.
It's kind of funny. I wrote that, but I've never really heard anybody say it. I'm sitting there thinking, I did that? It just sounds so much more impressive than it felt doing it. So thank you all for being here. We appreciate your coming here instead of going to work. Maybe that's just a good thing. Anyway, what I'd like to do is just introduce briefly the three panelists, and then we'll get into the nuts and bolts of things. First, I'd like to introduce down the end Mike Owen. Mike is the Chief Human Resource Officer and General Counsel at Easterseals. Next to Mike, we have Kevin McDonough. Kevin is the Executive Vice President of the Dickstein Associates Agency, a multi-line agency here in Central Jersey. And finally, we have Dave Rapuano. Dave is a partner at Archer Law. So to get things started, Mike, I understand, based on the conversations we've had, that you've really done some remarkable things at Easterseals and made significant changes and improvements. So I wonder if you could lead us through some of that.
Sure, thank you. Good morning, everybody. I've been at Easterseals New Jersey for about the last 6 years. In a month, it'll be 6 years. We are a health and human services organization that supports improvements and enrichment to the lives of people that have disabilities of all kinds throughout the state. One of our interesting challenges is that most of our employees are direct care workers who don't get paid a whole lot of money and do a whole lot of really hard work for people in their homes or people that need a lot of help. And they're some of the most important kinds of workers in the state, but they're also among the least paid and kind of the hardest to get. There's a real shortage of those folks. So one of the things that we've been doing at Easterseals over the time that I've been there is trying to create an atmosphere of engagement for them, an atmosphere where they really feel valued, and try to surround them with benefits, culture, treatment, and a variety of other things that make it seem like the best possible place that they could work. That helps give us a competitive advantage over anybody else who's also in the space trying to hire direct care workers. And we have a few metrics that have started to play out over the last few years that show that the work that we've been doing on that front has really borne some fruit. For example, when I first got there, we had turnover among people that we hired into those roles in their first year of over 60%. So, 6 out of every 10 people we hired into that role within their first year left. And this past year, we saw that drop all the way down to 18%, which is better than most organizations have in terms of turnover of any kind. So it's fun when you talk big talk, like I like to, about this kind of topic and about the value of engagement and atmosphere and treatment, to see actual data proving out the reality of how much impact it has. So that's just one of those things, and there's a few others like that. But the impact on productivity, the impact on what the actual performance of the organization is sometimes in a little bit of an inverse relationship to how much control, policy, rules, and effort you exert to try to direct and control people's behavior, and can come a little bit more interestingly from allowing them to be more themselves and creating a feeling that they can be whoever they want to be and contribute all that they're capable of.
Thank you. Thank you. No matter how well an organization is run, and Kevin runs a very effective organization, there are always going to be problems that need to be addressed. You all know, or any of you who are in human resources know, that if you put two people in a room for any length of time, sooner or later you're going to have a problem. And it's just plain true. I wonder, Kevin, if you could talk a little bit about some of the risks that you see in day-to-day business operations, and some of the solutions you offer.
Sure. Good morning. Well, I'm listening to Mike, and we're like the joy killer, the insurance agent, and the attorneys, and because we would come in and we'd say, well, there's certain process and procedures you have to follow, and you need to do this for proper risk management. You need to have this in place and that in place, and which is one way to approach it, and it is a very good practice. But from a standpoint of allowing Mike to make those significant changes in his business, having the right insurance in place allows you to do that with some sort of a stopgap, so that when two people do get in the wrong room together, or two of the wrong people get in the right room together, that you can always rely and fall back on the insurance. And Mike's organization is pretty large. Mike has a very long background in HR, as well as he's an attorney. So he has good skills in knowing where those boundaries are that he can be flexible with. A lot of businesses, especially small businesses, and I was talking to someone from New Jersey Biz who specializes in that, they don't have those kind of resources. And again, that's where the insurance can play an integral part in not only protecting them in case they do make a mistake, but it can also provide them with some resources to understand better what they need to do to protect themselves by creating some sort of a process. This past year we've seen a tremendous amount of laws passed or attempted to be passed, and we've seen a tremendous amount of how the media dictates how things are going to play out. And I don't think I need to go into the sheer number of things that have taken place as far as legislation and as far as movements, and social media has changed things dramatically, and a lot for the good. It's just, I think when we legislate how people should act, sometimes it becomes, the workplace becomes almost impossible to operate in. So again, the right insurance in place, having an employment practices liability policy, having some maybe directors and officers or management liability in place will certainly help you to be able to navigate that. So beyond that, I'm really impressed with what Mike has done. I don't see a lot of that. I read a lot about it, but I don't see a lot about that. So,
thank you. I wonder if you could just talk for a second. Data breach is a major issue for a lot of companies today, and for a lot of us who have had our credit card information stolen, borrowed, whatever. What sort of coverage companies have, or can they have?
Well, they don't have any coverage unless they purchased it. Unless, then I'm going to go for why I'm here. I'm with the Trusted Choice, so I'm an independent agent. So unless you have an independent agent who's coming in and figuring out what your exposures are, you probably don't have the right coverage. But a data breach or a cyber liability policy, they're typically written in a way that you can craft them to be specific to your organization and the exposures you have. But you think about it, people say, oh, the tech businesses, well, obviously we have a lot of people who do HR in here, the HR business, on the group side. If you have group insurance, you need it. If you're transmitting, PHI, I mean, it's just the myriad of things that a business owner is exposed to today, just by nature of opening the doors, and you have to be on the internet, right, in order to do business. It's amazing. And probably some of the most overlooked ones are like a restaurant, the credit card transactions with the multiple people and the turnover that takes place there. Those are the businesses that are underserved in that. The white-collar businesses typically have someone who's coming in and talk to them about that. But then you also get into the cyberbullying. What are your people doing? What kind of process do you have in place to make sure that that doesn't happen? So it's really, I mean, if I keep talking, everybody's going to get depressed. So, but there is a solution for just about any exposure that you have. And if we can't ensure the loss, we can at least ensure the legal fees, until it's proven that you've actually done something wrong. So,
Thank you. Kevin mentioned a number of new and pending legislation, particularly here in New Jersey lately. David, I wonder if you could talk a little bit about what you find as the legal environment surrounding small businesses, mid-sized businesses, and HR in particular.
So I've been practicing now, this is my 25th year, and I just doing employment law. And what I found over that period is I've been impressed that the courts and the legislatures have been working diligently and collegially across party aisles with the purpose of making life progressively easier for HR people. Do you think that's true? No, I don't think that's true. Okay?
So, not my experience.
They have been reactive. The courts and legislatures have been reactive to every perceived problem in the workplace, and have, in many cases, passed legislation that has been often ill-conceived. Not all legislation is necessarily ill-conceived, but there are many laws out there that are overly complex, difficult to interpret, and very difficult to apply in a dynamic workplace. And so we have that basically burdens HR and organizations all across the state, and frankly all across the country. Now, one of the things that I always take from my practice, which is just representing employers, is that we have to remember in all the things that we do that business is a risk proposition. We can't make money without any risk. And obviously we're in business, whether it's a for-profit or not-for-profit entity, essentially to either make money or create value. And we can't do that without risk. And so when we talk about the employment law issues that come up, just as we're talking about insurance, which is a risk mitigation, when we're talking about employment law issues, we're often talking about balancing risk. So for example, we deal with problem employees, and they may present a litigation risk, but at the same time, they're also presenting a risk to our organization by letting them remain in place. So we always have to think about a cost-benefit strategy in terms of dealing with employees in the workplace. One of the things that we have faced in New Jersey, and frankly it's happening all across the country, is the legislative and court reaction to a variety of trends. So there's been the idea of pay equity, the Me Too movement. These are all things that drive public opinion, and while one can support anybody's right to have pay equity and everybody's right to be free from harassment, at the same time, not every legislative solution to those obvious problems is a good solution. I simply point out, for example, the New Jersey pay equity law. I don't say this from the perspective of just a management attorney. The New Jersey Law Journal, which is a very progressive legal newspaper in New Jersey, often taking the side of, let's say, the more employee-friendly side on a variety of issues. They came out with an editorial shortly after the passage of this law that said this was a terrible law that basically foisted a gigantic unbearable burden on employers to prove that differences in pay, all differences in pay, are based on non-discriminatory factors, and all differences in pay between non-comparable positions. And so the editorial basically pointed out that this was an ill-conceived way of addressing a real problem. And these are the problems that employers face, is trying to navigate a very difficult environment in which there is a great deal of risk from unknown factors, while at the same time not simply giving up and throwing our hands in the air, because the obvious strategy of, look, we're going to pay everybody the exact same thing, for example, wouldn't be a way of motivating a workforce in this time period when people expect to be compensated for their efforts and not simply for occupying a spot. So anyway, that is kind of an overview of my practice, which is trying to help, and the issues that face all of you, which is trying to help businesses navigate risk. And I basically interface all day long with people like Mike, backed up by people like Kevin, who are providing oftentimes to my clients the backstop for severe risk. So when litigation arises, it's good to know that it's not going to bankrupt the company.
Thank you. Thank you. Mike, you've been listening to these two gentlemen, and I wonder if you could, based on what you heard from them, tell us what your nightmare is, what keeps you up at 2 o'clock in the morning.
Well, I guess the complicating factor for any organization is what everyone is doing out there. You know, when I first got into an HR leadership role, one of the things that I said was the frustrating part is that you can't control what every manager says and does. You know, the dilemma is that you're only organizationally, your ability to mitigate risk is based on everyone's behavior. So I think the way I try to combat that is to help senior leadership try to set a tone and a vision and a manner of treatment and behavior that filters through the organization. But what we know happens is that does not always work. In a previous conversation that we all had at one of your meetings, we talked about Me Too, and we talked about sexual harassment and training around that. And you know, one of the things you can be pretty sure that Fox News was providing training on anti-harassment, and it's happening anyway. And part of that is leadership, but part of that is just one of those things that, you know, these things go on. And that's to the point that both guys here are making, is that you need this backdrop, you need the underpinnings, you need the support system in order to create the flexibility for leadership to approach things in a really good way. I think it's all intertwined.
Thanks. Two thoughts struck me. One is, it always occurred to me that if we could get managers to manage effectively and properly, HR could basically go home, because it's problems that occur between managers and employees that bring most of the people to our door with an HR-related issue. The other is, this is thinking about sexual harassment training and the current Me Too movement, but it's a lot more than that. When this first became an issue in my world, when we first started at Prudential Insurance doing sexual harassment training, there's a moment in each session, each class, with each new group of managers, where you see, particularly among the males, a little light bulb comes on. And it's something along the lines of, oh God, I've done that. And the guilt begins. You hope the guilt begins. And hopefully they leave and they view their actions differently going forward, and they're a little more careful. But that's not always the case, and that's why people like David and me, for instance, stay in business because there are problems that come up. And I often still wish managers could manage more effectively so I could go home a little earlier. I don't know if it's appropriate yet, but let's try it anyway. Perhaps someone here has a question on one of these subjects. I hope to God. Yes, ma'am.
Well, a bunch of things in cohesion, working together, kind of separately, but overall shifting the atmosphere. We did move significantly toward encouraging managers to be more autonomous. We moved away from the idea that everything had to be rigidly following a set of rules and guidelines and compliance, and that everything had to be done to order, and that you couldn't make a decision unless your superior in the organization told you you could make a decision. So we're building an emphasis on empowerment and valuing people's contributions. We expanded benefits so that benefits would reach in sort of a Starbucks-like model. We expanded benefits so that people who worked as little as 15 hours a week could have access to benefits. And we have continued to make benefits available at a relatively low cost, knowing that that investment helps differentiate us in the marketplace. We've intentionally, through employee relations efforts, been specifically focused on job performance and real measurable reasons for taking employment actions as opposed to personal or emotional reasons for taking employment actions. I had another one there that I was thinking of along those lines. And performance-wise, in supporting a culture of performance, we've moved away from, to the point David made, about paying people real merit-based pay. We don't, for a long time in our organization, it was cost of living increases, and it was treated as if it were socialist is a loaded word in today's political climate, but it was treated as if everyone had to be treated equally, and it was as nonprofits work even more that way than for-profits do in terms of that mindset. Everyone's in it, everyone's contributing. Let's make sure everyone gets a fair thing, right? But that really dumbs down people's desire to give of themselves and contribute of themselves, right? The whole concept of employee engagement is around capturing people's discretionary effort, the extra effort that they want to give above and beyond just showing up at work and being there at 8 o'clock and leaving at 4:30 or whatever it's supposed to be. You know, that idea of capturing that discretionary effort is the whole key to success, business-wise, I think, whether you're small or large. And what we've tried to do, every different piece of that is designed to encourage and reward and keep people engaged and interested along the way. So there's a bunch of those things that have added up over time. We do an engagement survey every year, and we try to take steps as a result specifically of what we see. If people think that they don't trust management or that communication needs to be improved, we look at specific vehicles that we can address that do that. We listen to our employees. That's, I think, a big thing. It used to be a very top-down organization where the ivory tower would call out everything that was going to happen, and people would grumble about it or accept it depending on how they felt. And these days what we try to do is really take input from everybody and let them feel ownership in the decisions and the actions that the organization takes. And I think when you put all those things together over time, not in 6 months, a year, 2 years, 3 years, it takes a time for these things to play out in an organization, and it just, it has begun playing out.
Gentleman over here had a question, I believe.
That was my question.
No.
16 to 18. So, how long did it take? Was it a 6-year process?
It was pretty close to a 6-year process. I mean, we didn't start the first year I got there measuring first-year turnover and like with a specific plan. And that's one of my weak points, I think, is that I like to operate very strategically, and I don't operate as much with a really specific plan to achieve an outcome. I say, this is the outcome I want to achieve, and I'm going to fashion a whole lot of my actions around trying to achieve it. And I think it's fortunate sometimes when it plays out well, because it certainly doesn't always. But over the last 2 years, we started to see the drop really happen. So I guess I'd say the first 3 or 4 years were, shaking things up some, and then we started to see more movement over the last 2 to drop that number in particular. I'd also say that along the lines of lawsuits, because it's one of those things that we talk about and we worry about and that we feel like we can't entirely control, my organization used to see a lot of lawsuits, whether they were warranted or not. They came up a lot, and over the last 3 or 4 years, we only have had 2. And given the percentage that compares to the past, it's enormously better. And sometimes you have a philosophy of there's only so much control you can have over that. People are always going to sue. That's the environment we're in. But when you make an effort to try to treat people the right way, you get a lot less anger, and you get a lot fewer people who want to go and challenge the pay equity law because they're not mad. When people aren't mad, they don't tend to go seek counsel as easily.
Thanks again. Mm-hmm. Other questions? Yes, ma'am.
Thank you. You work with the senior leadership to set a tone that then filters down throughout the organization. Can you elaborate on some specific techniques or ways that you work with the senior leadership?
I think, sorry guys if I'm talking too much, I don't mean to be. I think the challenge for human resources professionals is the same one that it's been for a few decades now, is that the quote-unquote seat at the table is one that you really have to earn. And in order to work effectively with senior leadership, they have to feel like you're adding some significant value, right? They have to feel that they respect you, that you're an expert, that you carry knowledge that will benefit them. And I think the important thing to do is to try to find a way to express that. I often work with my own team on the idea of somebody's got a perspective, you've got another perspective. The goal is to figure out how to meet somewhere that is accomplishing the objectives well together. And typically in negotiations, what you have to do is find what that value is and work toward it together, and not be sort of like HR says you got to do this. Well, I don't want to. I want to do this. The challenge is to understand. I like to put it as the challenge is to understand the business of management and the senior leaders that you're working with as well as they do, so that you would be capable of managing the same thing they are. And when you're in that position and you can work with them that way, then all of a sudden it sort of changes the dynamic about how much you're actually able to influence.
I just want to jump in on that for a second, because it's often a challenge that HR faces, as well as HR counsel like myself, when dealing with management. And I want to echo everything that Mike just said, but also to add that one of the things I feel is very important in achieving that goal of convincing management that you're part of the team is understanding the underlying goal that the manager or management is trying to achieve. Because oftentimes managers or management perceives the HR function as a blocking function, blocking from doing what we want. I want to fire this person. You can't do it. Okay, well, you're blocking me. You're stopping me from doing what I want. But if we kind of turn the proposition around, and instead of blocking, we're more of a risk diversion and risk mitigation to say, I understand what you want. You want to get rid of this person because they're a drag on the organization. And here is a way that I can help you achieve your goals while also bringing it in with an acceptable level of risk that you would feel comfortable with. And so that is a really effective way of getting managers on board with understanding that what you're doing isn't stymieing them, it's actually helping them achieve their goals without opening up a can of worms that they also really don't want. So I think that's a really important aspect of all HR and all counseling functions, is to explain to the people you're giving advice to that your advice is designed to help them get to their goals, not to stop them from getting to their goals.
Other questions?
Thank you. Carrie Planamura from Creative Workforce Solutions. I'm sort of interested from a legal perspective. I work as a change agent and a coach, working specifically with executives and high potentials. And recently we've had many more inquiries about proactivity from companies. Years ago we dealt with the corporate integrity agreements of the pharmaceutical companies, and it was incumbent upon them to show some proactivity in terms of training and compliance to better their case and to limit their risk. I'm wondering if you see any of in the court cases, if proactivity, getting someone a coach or providing training to young managers helps a case, reduces risk, or just your feelings on that. I heard a statistic the other day that in the state of New Jersey, about 12 minutes of training per year goes to management. While we have expectations of young managers, many of them are not being trained on the expectations of the executive team or the company as a whole. So I'm curious on your thoughts of proactivity and providing resources to them.
Well, assuming this question is directed at me, I think that, at least at the outset, I think proactivity is an excellent way of mitigating legal risk. So the cases that are out there in New Jersey especially, but also nationally, the steps that an employer takes to train its workforce to avoid harassment and discrimination do go into an analysis of whether the employer has taken due care to avoid harassment. So these steps are very important. If you do not do them in New Jersey, you are actually potentially legally liable simply for the failure to have engaged in these proper steps. It certainly will not be helpful. In terms of how much time, in terms of whether it should be done annually, I tend to think that supervisors should be trained at least biannually. I would like to say annually, but I don't want to seem greedy if I'm the one who's doing the training. Employees should also be trained. As to the effectiveness of the training, I'll be honest with you. The EEOC, for example, has come out with studies that show that harassment training is actually fairly ineffective. And I'll tell you why. It's actually because most people are not harassers. Most men, most women are not harassers. The problem arises in workplaces because of people that I kind of, on a spin of the Me Too movement, I call the not me movement, which is they sit there throughout a training session and say, not me, not me. Not that I didn't do it, but this doesn't apply to me. I can do what I want because I have power, I have this, I have that. And those are the people that create problems in your organization. The problem oftentimes is not necessarily training that person. It's figuring out who they are and either siloing them or getting rid of them. Because these are the people who are what I consider to be the untrainable ones. The people who aren't going to listen. The people who are going to do bad things in the workplace. I mean, I've had sessions where I've trained people, I've told them things, and literally a week later I get a call that one of the managers in the training has done something that you know, my 11-year-old would know was wrong without any training. And they do it because of a feeling of that they're impervious to anything. And if we can take that away from them, then they may very well toe the line more in the workplace.
I'm going to jump in and say that because you had mentioned a coach, I've been going to an entrepreneurial coach for about 5 years, and one card I always carry around with me is, are you aware of the 4 management obstacles? And they are silent and or unrealistic expectations. And it's communication, right? I won't go into all the details, but then not saying what's on your mind, right? Communication. Not enough time spent with staff. Communication. Short-term view of staff. Communication. I won't go into the detail on it, but basically, for me, what it did is it made me look at situations where I might not have stopped and took the time to listen to, and deal with them in an effective way, as opposed to asking someone else to deal with something that I expressed to them. I didn't know what it was that their issue was because I didn't listen long enough, and so I expressed what I thought I heard to someone else, and that's the key thing, is that communication part of it. Those are the things that have made us a significant difference in just my own workspace and how to deal with people. And I've let more people go in that period of time than I've kept, mainly because as it started to drill down, we started to see as they were a drag on the organization. And there was no, the organization was not at fault for that. It was just something that they were not interested in things getting better. They were just interested in complaining about it. Now, I had the right insurance in place, so I wasn't worried about doing that. And if you do, I think it allows you some, and I know Mike does, because he's a corporate counsel. So, and he deals with a diverse group of people coming from a diverse background. So, with that in place, it allowed me the flexibility to do that. And some of those things were contrary to the risk management I teach people in the first place, where I would just somebody would say something about someone else, I'd call the other person in the room right then and there. You would see the change in that person who was the accuser and the person who was the accused. And sometimes it worked out, sometimes it didn't. But that communication, that effective communication within certain boundaries, allowed us to move on, to part ways, and sometimes, or there were some people who did change, myself included. So, yeah, communication's the key, right? So.
My just 2 cents on that is that I think it depends largely on the type of training that we're talking about. I think to the earlier point, if we're talking about compliance-related training on something like anti-harassment, it's mostly done to mitigate the risk of the organization. If we're talking about leadership training where people could learn new skills that they could actually apply that they may not have ever been exposed to, I think there can be some significant advantage. Not everybody benefits, but if you take a group of 20 people in a leadership class or something, and you get 7 of them gaining some significant skills from it, that's a pretty good percentage. So it depends to some extent on the type of training.
Yeah, I think that's obviously, training in and of itself is a good thing. Some things are a lot more difficult to train than others. Some things are obviously new skills are one thing, but to tell people things that they probably should have learned in kindergarten that they haven't learned yet, that may be more difficult.
Mm-hmm. In the back.
Woman in the back, please.
Good morning. Amina Massenberg from Essex County College. We're actually just started to implement a compliance department at Essex County College. So we're new in actually becoming more compliant and making sure that the focus is there. So my question for you, maybe more so to Mike than anyone else, as we roll out this compliance department and making sure that it's understood by the staff that there's not a separation from human resources and compliance, that they are essentially one and the same. It's just that one has a different focus than the other. As we, again, implement these new processes, what suggestions would you provide for Essex County College in order to make sure that that we do it correctly, that we make sure that we're engaging the workforce properly, and that we're efficient in what we do?
Well, thanks for the question. Having worked at a couple different colleges and universities in the state. I have a little bit of experience in that area. And I would say that the number one thing to do is to make sure that you are viewed as a partner trying to provide help to them, to the point we made earlier of not coming in as a compliance force to ensure that they're doing things the right way. It was met with enormous resistance when compliance is approached that way, especially when it's a new function. You're automatically going to be dealing with a huge amount of fear, concern, sensitivity around who's going to be looking at my stuff and the way I operate. So the number one thing is to communicate warmly your intentions and to work as a partner to help remediate anything that you find out there that needs improvement, because you're all part of the same team. You know, the hard part for people that are in compliance, I think, and for the compliance function is not understanding what the rules are and trying to make them happen. It's all the smooth interpersonal stuff that has to go on in order to make sure it's successful. So that's the number one tip by a long shot.
I think just building on something that all these gentlemen have said, communication, the ability to build a relationship with whoever you're serving is really key to being, I think, an effective HR person, an effective business person generally. I do some work with college students, graduate students in the area of management and human resources. And I'm often asked the question of, where in human resources should I start my career? And my answer, which doesn't make a lot of people happy, is that you should probably start your career somewhere else. Honest to God, get into finance, get into accounts payable, understand the business. If you don't understand what drives a business, you will never gain the respect of senior management. They have to know that you know what you're talking about in their world. My 2 cents. Other questions?
The topic of the equal pay law came up earlier in the discussion, but I'd like for the panel, if you would, to elaborate a little bit about the complexities behind that law, because it seems to me that it is way more complex than most employers even realize. So can you guys talk a little bit more about that?
So the equal pay law in New Jersey is one of the things that I think many people don't realize about the equal pay law is it's not gender-based. It applies to all 18 protected classifications in New Jersey. And I think I calculated out, I was helping my daughter with her math homework, and I relearned how to figure out permutations and combinations, and I figured out that there were 153 possible combinations of comparisons that could be made between protected classifications as to why someone would say so-and-so is being paid more than me, and that's illegal. That's far different than the I'm male, she's female, I'm being paid more, and there's one comparison to look at. Another main complicating factor of the equal pay law, there's several of them, is that the comparisons between jobs are not between people in the same job. They're people who are in similar jobs. So work that is substantially similar based on the skill, based on the effort, and experience for the job. But as you can see, you may have two very different jobs that involve substantially similar skill and effort, maybe different skills, but they're substantially similar. They're equivalent in terms of level. And so you have, until the courts decide, because the legislature obviously didn't offer any real guidance on this, until the courts decide what substantially similar is, there could be vastly different jobs being compared to say that the employees in those jobs are substantially similar. So that's a problem. But then the main problem with the law, okay, the main problem, and perhaps the thing that makes this law in my view, unfair, and in the view, for example, of the editorial board of the New Jersey Law Journal, also incredibly unfair, is that unlike most discrimination laws in which the employee has the burden of proof of showing that there's been discrimination, under this law, the legislature has flipped that burden. So there is discrimination. You are guilty until proven innocent, until you prove yourself innocent. You, the business, has the burden of demonstrating that a difference in pay between two people who work in these two types of positions, or in these positions that are substantially similar, that the difference in pay is wholly explained by legitimate factors. And the method of trying to make that set of proofs is incredibly complicated. It involves a weighing of 5 factors that the employer has to prove each one. And if the employer can't prove each one, then the fallback position is guilt, discrimination, liability, back pay for an incredibly long period of time, 6 years in this case. So the proofs are very difficult. I could speak for hours on what the proofs are, but suffice it to say that it's not apparent to any attorney who's looked at this exactly how you would prove, even when you know that the fact that there's been no discrimination, how you would prove that negative. And I'd say another factor that makes this law incredibly troubling is that in most discrimination cases, there's a statute of limitations. That means that you can't look back farther than X period of time to find a wrong. That applies in legal cases, whether it's a slip and fall, whether it's a contract case. There's some period of time that the legislature and the courts have said, look, it's not fair to foist upon someone the burden of having to go back and demonstrate what happened in the depths of time after the evidence is lost. So it's unfair to do that. In this case, the problem is that the legislature said, look, you have to be able to prove this about differences in pay that exist now, even though the cause of the difference in pay might very well have had its genesis 20 or 30 years ago. And so you won't be able to substantiate why it happened now. And further, if it was in fact discriminatory, you would be essentially having to pay back pay for a discriminatory decision that happened 20 or 30 years ago. And let's say it wasn't discriminatory, but you'd still have to prove that it wasn't discriminatory based on facts that probably no one in the organization has any recollection of. So this law really creates substantial difficulties for employers, and I think it's going to be a gold mine for employment, plaintiffs' attorneys. I'd say one other thing which really demonstrates that the legislature, in this case, the New Jersey legislature, had no idea what they were doing. And I've heard from multiple sources that this was a law that people just kept adding to, and the legislatures all said, we are not touching this thing. I wouldn't stand in the way of this, even if it involved, sacrificing children, because I'm not going to be having a commercial say I'm against pay equity. So it doesn't matter what's in the law. But one of the things you see in this law that really shows how senseless it is that the law says if there is a pay inequity, you cannot correct it by lowering someone's pay. So if you had an outlier, you find out in your organization, oh my God, this guy's making $50,000 more than these 20 other people because 20 years ago, his old boy contact said, let's give you more money because you're a man. You cannot reduce that person's pay without violating the law. You have to raise everybody else's pay. Now, why would the legislature say that you couldn't reduce someone who's been getting an unfair windfall for 20 years to make their pay equitable to the market? There's no reason why you would say that. Why they said that is for politics. Well, we don't want anybody to get hurt by this law, any employees. So let's just say that. And no one thought about it. As you can tell, I actually have no problem. First of all, I have no problem with pay equity as a concept. I think it's a wonderful thing. But this law is maybe the worst law I've seen passed out there. And I don't get all worked up about paid sick leave or paid family leave. Those things, businesses, we can deal with. We can deal with that. Those are all just compliance issues. This one is scary.
David, does that $1 million that they have to raise people's pay, does that go back 6 years?
So,
if it's been going on for that long?
Theoretically, if the employee themselves brought a complaint and said, look, I should have gotten paid X, that would go back 6 years. So yes, I mean, let's say someone was getting paid that extra $50,000 based on some, clearly discriminatory pay. The delta between the two would go back 6 years. Now, of course, most organizations, there isn't a $50,000 delta between similarly situated employees, but yeah, the costs of this could be incredibly expensive, this is something that may very well really serve to raise the costs of insurance because it's really at this point an unquantifiable risk.
Well, on that note, that's one of the restrictions on most employment practices policies. And so if they give you anything, they give you defense only, and it's usually sublimited. They've thrown that in. They've thrown it in before this law took place, so I don't know what's going to happen going forward. But it's certainly something that people are going to spend a lot of money on having their attorney take a look at how they're paying people. Something totally different.
It's a very difficult thing because most organizations simply don't know why there exist pay differences. Another thing I should point out is that the whole idea of asking people what they're making at their present job, it's not illegal yet in New Jersey. It may be illegal in some places, but you shouldn't do it because it's clearly a violation of this statute to pay people based on, or it could lead easily to violations of this statute to pay people if I go in for a job and I'm making $100,000 and so they offer me $105,000 to come and someone else is making $80,000, and let's presume because there's going to always be some differences in protected classifications, I'm old and bald and they may be female or from a different ethnicity, and they are making less, and their employer says, well, I'm going to pay you less because you're making less now. I need less to bring you in. Well, the problem is that the law is structured to say, look, if there's any pay inequity and your explanation is the type that would perpetuate discrimination, then you can't apply it, even if it's a legitimate factor. And using existing pay is clearly a way of perpetuating existing discriminatory pay. I do want to point out when you see that the whole idea of 70 cents on the dollar, this one is sort of a galling statistic when they say, for example, women make 70 cents on the dollar of what men make. That's not comparing comparable jobs. That's overall compensation of females versus overall compensation of males. When you actually correct for similar jobs, there remains a difference. So there is clearly some gender pay inequity, but it's far smaller than 30%. It's probably in around 5% when you're correcting for the same work.
It's interesting to me when you're old and bald. I won't hold that against you.
Three out of four up here are.
Yeah, well, I'm the old one. So. Back, it had to be in the early 1980s when I was at Prudential. And it actually arose out of compensation issues. We go through this annual compensation dance, if you would, to determine who got paid how much because all management salaries rose at the same time or didn't raise. We had a group of industrial, organizational, psychologists looking at differences between this manager and that manager, who happen to be male and female, and trying to understand why they were different to start with. Like, what happened, where along the line? And we looked at a number of people. We didn't call it pay equity at this time. It was just, how come we're paying that one more than we're paying that one? But each case we looked at, we'd say, oh, well, okay, but here's what happened to his career, or happened in his career, that caused him to be paid the way he's being paid. And those things didn't happen in her career, or vice versa. There were so many, to David's point, so many variables that affected how someone was paid after they've been in an organization for 5, 10, 15 years. We could never quite figure out what was the right formula to fix that. So it's an old issue, it's a new issue, and it will be an issue 10 years from now.
Just want to toss 2 cents in on it if I can. I think a law like this is super complex and completely out of all of our control. And part of that makes it scary and difficult, and provides also opportunity for all kinds of people as these things do. The thing that we can control, and particularly that HR can influence in an organization, is its good faith efforts to try to make sure that these things are done the right way, and for business-based reasons and for non-discriminatory reasons. And for the most part, that is always going to remain the best defense. No matter how complex or tricky or how the law gets modified, the best approach is always going to be to truly engage in practices where you review compensation across the organization, you look at comparable jobs, you compare, and you provide an approach that says we're going to treat everyone in a way that is appropriately based on their business contribution and nothing else. And the more the organization does that, the more you've done everything you possibly can anyway to mitigate the next law that comes around too.
Just the last question.
My question is regarding liabilities. What we're seeing now is everybody's business, all of a sudden they're putting in more lax rules, whether it's the way you dress, whether it's certain parties that they're having at work for employees, employee trips or things like that. What type of liabilities does that open the company to, especially if you're supplying maybe alcohol or things like that to your employees?
Well, it opens them up to all kinds of liability, right? Yeah. But this is part of the point that David made earlier, was everything is a risk. Everything in a business is an evaluation of a risk and a cost-benefit analysis to what you're doing. So the question is, how do you want to approach this risk? Do you want to approach it as a risk that I'm willing to take because the benefits outweigh my concerns, or do you want to look at it in a different way? And I think every organization has the benefit of being able to find where it falls on the risk tolerance map. But the reason for some of those things is that it creates an atmosphere where people feel more engaged and where they want to be there. And I think there's been a little bit of a return to that because there had been such a movement away from that. I think there's become an awareness that some middle ground is reasonable. But, when you talk about supplying alcohol, it's all about a moderation and control over the experience to some extent, right? And all about how so much of life is how it gets done, not what you do, but how you do it. So anyway, just a little thought on that.
I think as well, from a standpoint of where are you doing that? If you're doing it in your office, you're hosting, happy hours in your office. That's probably a no-no. But if you're holding an event at an establishment that has the right controls in place, and the way that you present it to people, I think that's something that if you get your morale up, and nothing bad does happen, although it does. I was talking to somebody before the meeting was talking about something very similar to this on a trip. But there's a lot of insurances you can put in place, and in today's environment where people are traveling greater distances to do things, whether across the country or somewhere down south or in Europe. There is also, executive insurance that you can put in place, travel accident policies and things like that will help as well mitigate that, because you don't want one of your employees who's in a country where an accident or violation of the driving rules is criminal, and they get thrown in jail for that. You want to make sure that you have the right foreign liability coverage in place to make sure that you can get them out. So those things are all, they're all possible to do. There's, parameters that you need to do it by, and obviously, Mike's probably better suited to talk about that, but there's the parameters, and then there's making sure that you have the right insurance for those things, which means that you have to sit down and talk to your insurance person as a professional, as someone that maybe you talk to before you do those things, to see what kind of coverage you do have, what's available, what it'll cost, and what the risks are based upon the experiences we have with people doing those kind of things. We see that as well, as well as David does, and I'm sure Mike does or has.
Yeah, so that cost-benefit analysis is controlled by insurance. If you've got the insurance that protects you, you know what your ceiling is on what you're going to lose. Those that don't have it could lose their whole business, right? And that's part of the concept of tying it all together.
Just from my personal perspective, I have 3 kids that I need to send to college, so I really am encouraging all of you in the audience to have really raucous parties, because I think that's very helpful. I do think, though, that I echo everything that my co-panelists here said. It's like Mike said, it's not what you do, it's how you do it. So if you're having the party and it turns into something where people are acting irresponsibly, then that should either be dealt with, or the venue or the type of party should be rethought. But generally speaking, the idea of employee interaction isn't to be avoided, it's to be managed.
Well, Mike, Kevin, and David, on behalf of NJBIZ, I want to thank you for your...
Yeah, there you go.
Sure.
Everyone here?
Hi, I'm Denise Pappas, and I have, this is a new experience for me to be in human resources, and from an employee's perspective, I have a question. I noticed that there's more discrimination against people that are older than 50 in the workplace, and I was wondering what your thoughts are, just from each of your perspectives, on if there's going to be additional legislation, for example, if there's ways in which there's risks to control. Thank you.
So just from my perspective, I'm not sure that in my experience, I don't think that there's more discrimination against those over 50 than there was before. In fact, my guess is there may even be less, although my own perspective as I've gotten older, perhaps I notice it more. I doubt that there's going to be much in terms of new legislation, partly because age discrimination is difficult. It's more difficult than other forms of discrimination because, as opposed to certain immutable characteristics like gender and race and things like that don't change over a person's lifetime and shouldn't have really any effect on their ability to do work, as people get older, oftentimes their desires in the workplace change, the amount of time they're willing to spend at work changes. I don't mean to say this is a specific to any particular employees, but we do see a trend towards people moving out of the workplace, obviously, as they get older. And also, it can't be disputed that, especially as we get into ages, above 65, 70 years old, people's capacity to do work in some situations will diminish. So the law has always tried to recognize that age is something that happens to everyone and tries to protect against discrimination while at the same time recognizing that there may be legitimate factors for which age is a natural corollary where the actual factors themselves aren't discriminatory. But I do think that businesses need to be aware of the value of older employees and not worry so much about a time horizon that exceeds the time that most employees stay in the business. So I think many businesses will say, I don't want to hire someone who's 55 because they're going to retire in 7 years. Well, how many of their 30-year-old employees are going to be there in 7 years in a workforce where people move all the time? So I do think it's incumbent on businesses to recognize that the mobility of their workforce is not necessarily a terrible thing, and that people who are older may very well bring great value to the workforce, even though they might not have a 40-year time span to work.
I will say, having heard your question, and having been at a post-age 50, at times unemployed, it really feels like there is age discrimination, actually kind of rampant age discrimination in the employment market. I don't know so much about within a given company that a younger person might be favored over, an older person. But in the employment market generally, I would say there's loads of age discrimination. And I happen to agree that it's very difficult to prove, but it's not hard to observe.
Yeah, I don't disagree with that, by the way. I didn't want to minimize the idea. I just don't think there's going to be a legislative change about it.
Yeah, the challenge is that there has been clear legislation preventing age discrimination for quite some time.
Right.
So you have to hope then, if your premise is to be taken to its fullest extent, that it becomes something like we're seeing the national outcry around other elements of discrimination that galvanize people. If we wanted to see more, we'd need to see more like that, I think, in order to move it.
And I'm not sure that's going to happen, because it seems to me that age, as I get older, is still the one area of discrimination that everybody seems to remain okay with. I'm not saying that's good. I just think that we have not come to that consensus as a society that age is to be valued.
Yeah, and I see it from a standpoint as a small employer, not from the insurance side, but as a small employer, where I have somebody particularly that works for me that is just there. They're 61. I mean, I'm 61. They're 61, and they're really just there for their benefits. And I think we talked about early about the fact that those are the people that kind of, there's no more enthusiasm for the job and things like that. I think you have those people, and then I think you have people like Ed who will who will do something like this, And I have no intentions of stopping working for at least 10 years. I may slow down, and I think we have a lot of that where we have somebody who's back to 3 days a week, something like that, because there's an experience that those people have that a great deal of people that are coming into the business don't, or they're not coming into the business. So I think it works both ways. I think if the person is out there looking for a job, I agree. There's age discrimination. It's all over. Really difficult to prove. But there definitely is if someone's coming and looking for a job. Within an organization, I don't think it's what it used to be, because a lot of the particular industries are hurting for people, and their average age is anywhere from, I saw something the other day where they said the average welder is 49 years old. In the insurance business, it's worse. It's 56. So I mean, there's this. There's these aging workforces where someone is already employed, where we might end up keeping somebody, because they can fill a position part-time because of the knowledge that they have. And there are other people who are just keeping their jobs so they can get to 65 and not have to pay their benefits any longer.
I'm 72 years old, and in my head, I'm still 22. But my body reminds me, particularly early in the morning, that maybe I'm not 22 anymore. But I haven't been discriminated against in a long time. In fact, if anything else, because I am old and have a lot of experience, I benefit from not having hair as much as I might like. And the fact that my mustache is now white, people think that's wisdom. But and I'll let them go down that path.
Hi,
Yes.
this is a two-part question for David. Point of information about the pay equity law. Does it look at base salary only or total comp? So if someone has incentives or commissions, or if there's like...
Total compensation, including benefits.
But what if there's variable comp that's performance and results driven?
Well, that may certainly go into the explanation that the employer makes for the legitimate business factors, and undoubtedly that will be an argument that some employer will make in the future, and we'll see how courts deal with it. One of the troubling aspects after an employer is able to make this 5-factor test to demonstrate that its pay, the factors that explain the pay difference, is that then the plaintiff, the accuser, gets to come back and say that, hey, this factor that you used, this factor, there's an alternative that you could have used that would have affected me less. And if they can show that, then the game is over. And so the employee and the court becomes what it's always said it should not be, which is a superhuman resources department second-guessing employers. So again, that's a troubling aspect. I don't know, I can easily answer your question that it's all compensation and benefits. How exactly the courts are going to parse out an explanation that says, look, X person sold more widgets than Y person, I think would depend on the facts of the situation.
And then do you see value in companies undertaking external benchmarking studies?
Yeah, I think that's something that I see as in sort of all the things that swirl out there of what companies can be doing. It's not absolutely clear what they could and should be doing, but that's one of the things I think is that companies are going to do, and they're going to say, look, we have benchmarked our pay, we have looked at our pay, and we've used these benchmarks to establish pay rates. Will it be the be-all and end-all? I don't know. I've looked at a lot of benchmarks that my clients have done, and I've oftentimes, in conjunction with my HR counterparts, have scratched our heads at how the actual benchmarks are derived. It seems like there's a little bit of a black box associated with some of them. But I do think that kind of goes to what Mike had said about making your best efforts, doing what you think is going to demonstrate that you have followed what I consider to be the golden rule of all employment law and all dealings with your employees. This is, if you take one thing away from this session from me, it would be fair or at least look like it. Okay?
Thank you.
Other questions? We seem to be done. So I'll try this again. To my fellow panelists, or I'm not a panelist, Mike, David, and Kevin, thank you very much on behalf of NJBIZ and personally for being great panelists.
Thank you very much.
Thank you. Thanks, everybody.
Thank you.
And I'd like to thank Ed for the job he did moderating the panel this morning. So thank you, Ed. So some house cleaning. Coverage of this event will be in the next edition of NJBIZ. It will also be on the NJBIZ website later this afternoon, and will be on our YouTube channel as well. So plenty of coverage. If you missed anything or you want to go back and hear it again, it will be available to you. Our next panel discussion is scheduled for August the 14th. The topic will be healthcare technology, and we look forward to all of you coming back for that. Trial subscriptions to NJBIZ are available if you're not really familiar with the product and you want to get familiar with it. See Anna Acquaviva over there at the table, and she will get you started on a subscription to NJBIZ. So with that, I thank all of you for coming today, and we'll see you next month.